We'll proceed with the next case on the docket, Department of Children and Families versus EW and SW. Okay.
But it came from this court. May it please the court.
Okay.
It came from this court, was issued around November 14th, and it, in essence, because it was one short paragraph, holds the way my arguments were written in the brief, and that is that the time periods for a dependency case are directory and not...
Did you file a notice of supplemental authority with regard to that case?
No, I didn't, sir.
Okay, then you can still file that, but I think our general rules are you can't argue the case to us today if you didn't.
Just give us the site so they will know the site. Is it a Westlaw site or is it...
No, it's brand new. I think it's November 14th from this court.
Okay, well, you'll supply us with a notice of supplemental authority
Sure.
and opposing counsel, and that was November 14th.
Yes, sir, I'm pretty
Okay,
sure.
and you're saying the essence of the case is that it's basically says that time standards are directory as opposed to...
I'm sorry, I did find it. I had it hidden in my brief here. The case is R.W. versus Department. It's November 14th, and it's per curiam.
Okay, and you're saying that your notice of supplemental authority will say that it stands for the proposition that the time standards, I think you said, are
Yes.
directive as opposed to mandatory?
Yes, there is only one sentence, although it's a long one, and they cite the D.D. versus Department case, 849. D.D. is cited in...
Well, I mean, there are other cases that basically say the same thing, aren't there?
Yes.
Okay. All right. Go ahead.
Okay, well, that is essentially the argument that I'm making here, is that the trial court could not dismiss the petition for adjudication of dependency based on what was argued by the guardian ad litem's attorney at the hearing on her motion to dismiss.
Well, was the argument below that it was mandatory, or was the argument below that that the department had to show some risk as of the point in time of the hearing and had nothing in the file to show it?
Well, I don't think that's the way you could phrase it. I think the argument that was made was essentially empathetic, sympathetic kind of an argument. The guardian ad litem said that she was arguing on behalf of the children. She also, because this case had gone on for more than a year, she also argued that the mother, she believed that the mother would not harm the children, and therefore the children were not getting bonded with her, and because this case had gone on so long, it wasn't in the best...
You would at least agree that the statutes require that cases like this be expedited. And there's some statutory language, although you want to argue that, you know, these time frames are directive as opposed to mandatory. You would at least agree that the statutes require that these types of cases be expedited and that they not linger. And that there's another statutory provision, 39506, that says that the adjudicatory hearing shall be held within 30 days of the date of arraignment unless a continuance is granted. So that brings to the forefront the issue as to the number of continuances and why they were granted, and we need to take a look at that to determine whether in the facts and circumstances of this case that this cause of action just simply went on way too long. But you would at least agree it should be expedited, wouldn't you?
I'll agree that the way the statutes set up the different periods of time, that yes, that is expedited when compared to, say, criminal cases or civil.
And there were numerous continuances in this case, but there were some continuances that were granted by the trial court, and we don't know why those continuances were granted. And we have a situation where this case lingered for a year, or maybe a little bit more, but it was approximately a year without an adjudicatory hearing.
Yes.
And so explain to me how that comports with the general notion that the case needs to be expedited.
I don't have a great answer for that one. There were a number of continuances that occurred during pretrial hearings that were off the record, and so we don't know what the reasons were. The last motion to continue that we have was due to the mother's request for continuance because she wanted to have her medical expert present for the trial, and
that continuance was basically made at the time that the trial court decided that this was going to be dismissed. Isn't that correct? I mean, she became concerned that her witness may not be available, but the trial court had already decided to dismiss the case at the time that continuance was made, so that doesn't make any difference, does it?
Well, I thought it was made before. Perhaps I'm wrong.
I may be wrong about that too, but I thought my memory told me that the mother's continuance was made at about the time the trial court decided to dismiss it, and therefore there wasn't any need for a continuance.
And I brought that up only because that was the only other motion to continue that was written that was in the record that we had.
Doesn't the record reflect that the judge reviewed not only the time standards, but that the services offered to the mother and the family, and that there was no basis to find dependency? Would that be accurate, based on the judge's order?
Well, I don't think he did that, but if he did, then that was incorrect because there wasn't any evidence before him to show that this was true.
Well, doesn't the record reflect in the order show that the judge reviewed the case file, looked at the services being offered, the mother's compliance with those services, and the time, and then decided that there was no showing of dependency?
I don't recall that in order, but I'll take your word for it, Judge Thompson. I'm not saying it's not there.
Didn't the trial court also ask the department whether it had any witnesses that would testify that, whether it would be dangerous for the children to reside with their mother, and the department said, we don't know?
At that point in time, I don't think that that's what our trial attorney intended to say. I think it was more like, well, I can't say verbatim what our testimony is going to be. And that's what I thought.
Don't you agree this case just went on way too long? I mean, there was really no reason for it to linger this long, and it just runs counter to the general principle embodied in the statute. So these cases need to be expedited because of the fact that children are taken away from their parents.
Yes,
and placed elsewhere.
This case did go on too long, but this is very serious. 2 1.5-year-old children had burns on themselves. There were second-degree burns, I believe.
The trial court kind of addressed that, too. I mean, and the trial court didn't seem to be too impressed that this was serious enough not to return the children to the parent.
But there wasn't any evidence that was taken at that hearing.
And you didn't have any to offer, did you? I mean, when the trial court asked, do you have any witnesses that will tell me under oath whether it's dangerous for these children to go back with the parent? And my notes indicate that the department said, we don't know.
Again, I think it was he didn't know verbatim what they would say. We did have witnesses, though. That was not a problem.
You had witnesses there available to testify?
No, we were there for a motion to dismiss.
But did the court make this specific finding? Here's what the second page of the order. The court specifically finds that for these 3 children, the risk at this time does not warrant further state involvement in their lives. Assume there are 2 arguments being made. One, that there's not information sufficient to show dependency, and 2, that there's a, quote, time problem, close quote. Isn't that enough basis to affirm the trial judge? That is, he made a specific finding that there was not enough evidence to show dependency.
But he didn't have any evidence in front of him. And that was true for the motion to dismiss, too. There wasn't any evidence.
The argument is it should go back for a hearing on the merits where each side can present evidence, testimony, witnesses, and then the court, if appropriate, should enter the order finding dependency is no longer appropriate.
I'd like the petition to be reinstated. And at a minimum, yes, I'd like it to go back to the judge for a hearing on it.
Even if the time frames are not mandatory, is there some outside limit? I mean, could a case meander for 3, 4, 5 years and not be subject to dismissal just for the sheer delay involved?
I can't be a judge on that issue, but I would imagine that an argument along those lines could be made at some point in time. I am unaware of any law that says that.
Didn't this court essentially give a warning, a harbinger that, cases that linger too long are not going to be tolerated in AR versus the Department 784, 7 seconds, 622, and this court said, you're talking about a nearly 11-month delay, that was just unacceptable because cases should be handled expeditiously, and we said by publication of this opinion, we hereby advise that delays such as those involved in this case will not be countenanced. And here we are again with a case that's lingered for 12 months.
Well,
It's not as if you're surprised, or that you should be surprised that this court would take the position that when we talk about, when the statutes talk about handling cases expeditiously, that a case that lingers for a year without an adjudicatory hearing, and based on some continuances, that the record doesn't even explain as to why they were granted, that you're going to have a problem with a case that lingers that long.
But under that theory, then you could have a parent move for a continuance and just keep going, and then at some point in
That's
time.
not what happened here. I mean, the parents, these continuances were, some were granted at the behest of the department, weren't they? And
Yes.
some were the court just didn't have the adjudicatory hearing and just set it for another date. We don't know why.
That's correct. But, I mean, it does allow, the idea that cases get too old and should be dismissed runs contrary to a due process request from the
Well, then
department.
what does the term expedite or expeditiously mean when the legislature tells us that, that's how these cases should be handled? What does that mean?
There's also a phrase in the statute that governs shelter hearings where it refers to continuances, and it says the case can be continued based on good grounds. Again, I'm arguing this is a very serious case because of the nature of the wounds to these toddlers, and the guardian was not in a good position.
You don't
when she
even
was
really know.
arguing.
Do you even really know? Is there anything in the record that tells us how these injuries were inflicted? The mother said one thing, and then I think contradicted herself, or took some sort of a test, I think, that indicated that she may not have been completely truthful. But the trial judge, I think, when reviewing all that, came up with the quote that Judge Thompson pulled out of the court order that said that the trial court was not concerned that returning these children to the parent would be harmful to them.
That wasn't based on any evidence.
Let me ask you this question. Whose obligation is it to set an adjudicatory hearing?
I don't know that the department has.
Well, my question is, whose obligation is it to set a call for, set up, schedule, or request a court to set an adjudicatory hearing?
I believe the statutes say that it falls in line with, first there's a shelter hearing and so many days for a petition to be filed, and then so many days for an arraignment. And so all of that looks to actions by the department. As far as setting the trial date, that in general is done in a collaboration of the parties.
Well, let's say you have a review hearing, and at some point somebody says this case is ripe for an adjudicatory hearing. Whose obligation is it? Is it the court to go through the files periodically every 6 months and then set it for an adjudicatory hearing? Is it the department? Is it the guardian ad litem in conjunction with the parent? Whose obligation is it to see that there are facts presented to the trial judge?
I don't know that anybody has that responsibility. The department in general.
Shouldn't it be the department?
Yes.
Since you have since you've removed the child,
Yes.
in this case,
Yes.
the child's out of the home, you've got tasks for the mother to do. Isn't it the department's obligation to set an adjudicatory hearing?
Yes, and that
Was
that
one
is-
called for and set in this case by the department?
was one called for by the department?
A motion or a petition to set an adjudicatory hearing, or a call for an adjudicatory hearing?
Not from my record. I don't know. I'm assuming because that's the way we run.
Yes, sir.
But I don't know.
So basically, your argument is that, because this case is serious and because the injuries to these children were serious, although I don't know that the record really indicates how they were the cause, and the trial court didn't seem to be too concerned about returning the children, that, this case should be reinstated and continue.
Well,
Is that basically what you're arguing to?
Yes, but I also wanted to raise, and I don't know whether I did it well in the brief, was due process of the department.
Well, if you have the obligation of setting an adjudicatory hearing, or once you get to the petition, or don't you have the obligation after a period of time, let's say a year, to say we're ready to move forward with evidence, testimony from witnesses, from the department employees, to show the status of the children and what we should do next?
Well, the case is reviewed by judicial review every 6 months.
Absolutely.
And so that kind of information does come up. My hands are tied in the sense that I just don't know why this case has continued. But it is very unusual by standards. You haven't seen, meaning this court hasn't seen another case like this with the...
Can you tell us how many times the case was continued at the request of the parents, other than the last request that you alluded to before?
No, sir.
Let me ask you this. The motion to dismiss that was filed by the GAL didn't purport to be a standard motion to dismiss to attack the sufficiency of the petition.
Correct, according to
The basis of the motion is, look at all these time delays, and in addition, the children are no longer at risk of imminent harm, and therefore either dismiss or reunify the children with their mother immediately. Doesn't that put the department on notice that when that comes up for hearing, they better be in a position to address evidentiary matters? If a basis of the motion is the kids are no longer at risk, shouldn't they have witnesses there if they believe the kids are still at risk? It's no longer a motion on the pleadings. It appears to be what would be dealt with as an evidentiary hearing. Or it would be subject to a motion to strike. Judge, you shouldn't hear this motion. It's unauthorized because the only motion to dismiss has to be attacking the pleadings. That's not what happened. They came and the motion was heard on its merits. And the essence of it would make it sound like you better be ready to present some evidence if you want to argue against this motion.
I'm guessing that the trial attorney our department's attorney, took a look at the motion and said this just is so weak according to the rule that I'm not going to have people there, and it's just on the motion to dismiss anyway. I've got about 2.5 minutes.
Think you want to reserve that?
Yes.
Okay. Okay, wait just a second. All right.
Please the court. My name is Tim Strauss. I represent the father in this proceeding in the appellate court. I also represent the father in the case below, so I may be able to provide some information to the court about other matters that are pending.
Just tell us what's in the record.
What's in the record with regard to, sir?
Yes, sir. Just tell us. You said I thought you may have alluded to some argument that may pertain to another record somewhere. Just confine your argument to the record before this particular court.
Yes, sir.
In this case. All right.
Yes, sir. The position I think is fairly clear. The motion states, and I think it was filed on March 2nd and served on March 2nd for hearing on March 27th, 25 days in advance. And the guardian ad litem's motion specifically stated its grounds. All this time has passed. We're not trying to create a speedy trial rule or anything that makes it mandatory, going to an adjudicatory hearing mandatory. And what it says instead is that there's no present threat to the children in the intervening period of time, which at that point is 11 months.
I'm sorry.
I'm sorry. Let me just ask one brief question.
Yes, sir.
Judge Palmer. Did I understand you to say you were or were not the trial attorney below?
I was.
Okay. When you went to the hearing on the motion to dismiss, the trial judge asked the department, well, do you have any witnesses ready to go under oath that would testify as to whether there's a present danger of returning these children to the parent? Do you recall what their response was?
To be candid, I don't think I was present at the lower court, that particular lower court hearing.
Okay.
I could not be, but I recall the transcript, and it's cited in my brief, and they said, I don't know.
Okay.
And I think that's the real issue here. I think that when a litigant gets a motion that says there's no present threat, they have 25 days in advance. They don't, at that hearing, raise the issue of, Judge, we didn't have enough time, there's a witness available, we're not prepared. And when the judge specifically asks for that basis, that legal basis of the court's ruling, is there a present threat, which is the case law that must be sustained in order to sustain independency, I don't know what else the trial court could do.
What evidence was presented, if any, in support of the allegation in the motion to dismiss that the children were no longer at risk?
The court inquired of Edith Rivera, who was the actual physical guardian ad litem, the lay guardian ad litem. And the court inquired specifically of Ms. Rivera whether or not there was any threat, what she'd observed with relation to the contact between the kids and the mother for the last 11 months. And Ms. Rivera specified specifically, and I think it's on the record, that she says she couldn't imagine that anyone would perceive that there would be a risk to these
She
children.
testified at the hearing under oath?
No.
Was she subject to cross-examination by the department?
She could have been. She could have been asked to be. I can't. From the way I read the record, it was not under oath, and I believe the guardian ad litem or the order entered by the court specifically states that. So that's true. I mean, I'm not going to argue that point. I do believe that she was not.
And the
under oath.
basis of the motion was not just the time frame, right? It's not your position that if all that had been established was for unknown reasons this thing has gone on for 12 months, that's too long a time, it needs to be dismissed. That wouldn't be enough, you agree? You have to look at what's in the best interest of the kids anyway.
Absolutely. And the guardian ad litem's position in their motion and the court's position in its order, it says specifically in the court order, again, this court, by its ruling, is not making or defining a speedy trial rule. Rather, based on all of the circumstances, it finds, and I'm going to leave that blank, the risk at this time does not warrant further state involvement in their lives close to 12 months after initial removal. My reading of this case is very simple. There is a requirement that you have a present threat in order to find the status of dependency. They said the present threat doesn't exist.
Why not call for an adjudicatory hearing where witnesses, Ms. Rivera, the parents, and the children of appropriate age could present evidence, testimony, examination? The court could say these children are not dependent, or they are dependent but can be returned home supervised with assistance from the department. It struck me somewhat curious as the way the chronology of the case and the disposition of the case was handled.
From the record, it appears that what was happening is we had 3 triplets. They were very young.
A set of triplets.
A set of triplets. Yeah, we don't have 9 children. I imagine we have 3. And they're very young, and they had been separated for a period of 11 months.
I understand that, and I understand the disposition. My question is, why didn't either you or the guardian say it's time for the adjudicatory hearing because we can show that there is no present danger and that the children are doing well and that they should be returned to their mother, either supervised or unsupervised?
I think that's what the guardian did in their motion. I honestly, as I read the motion, that is precisely what they said.
Was the motion an evidentiary hearing, or was it an argument based on the statutes and the case law presented?
My experience in these things in front of the trial courts are that they usually start out as argument. When some party requests evidence to be presented, then evidence is presented. So I know that as a litigant, when I see a factually based motion, and this is a factually based motion, I need to be prepared to present evidence and to on both sides, when I'm presenting on behalf of the movement and in defending it on behalf of a respondent to a motion. So my feeling about this is that there should have been someone there. There was someone there. Ms. Rivera was there. And she did state, unfortunately not under oath, but she did state precisely what it is that were the grounds for the motion. And that factual basis, it seems very clear to me, is what the court relied upon without objection from the department. At no point did the department say, oh my gosh, Ms. Rivera is not under oath. And it's not like they're represented by lay folks. They're represented by lawyers. I think that there's indeed a waiver of that if that occurred in court. I know the guardian ad litem's brief, I think, asserts that there's an ability to accept some degree of credibility from the guardian ad litem program. But the bottom line is here, what happened, and I think it truly is a mountain making a mountain out of a molehill, the issue of the timeframes. The only relevance of the timeframes to me is during that period of time, things happened. Compliance with the case plan happened. Observation by the department happened. Observation by the guardian ad litem happened that led to the inescapable conclusion that by the time of the hearing, the children were no longer being threatened by placement with
Well, isn't it also relevant in this regard? If the time frame is not mandatory, but it's advisory, it seems to me what that would mean is if you pass the deadlines, there's not an automatic dismissal, but the court should look at all of the facts and circumstances of the individual case to determine how best to dispose of the case. And all of the history of the delays would be one of the factors, along with whatever else you had about what happened on the case plan and how the kids were doing, et cetera. Is that fair?
I think that would be fair, and that's precisely what's said by the court, I think on page 348 of the record, the order under appeal. But it isn't to the extent that if the time frame passed, it was 11 months, and mom did nothing to rehabilitate herself, and she wasn't visiting the kids, I don't know why you would ever consider that it took 11 months to go to trial in that circumstance. So I think it's all very circumstance dependent. And in this particular case, I don't think it can be said in reading this record that the court, given the information that was not objected to and provided to the court at the time of the hearing, erred in finding that there was no present threat after giving the opportunity to present witnesses about that. And I think it's a very narrow issue. I don't think it relates to time frames. I think it relates to a definitive definition of what is dependency. Dependency is having to have a present threat to the child. The failure to be able to show that in the face of contrary evidence brought before the court or information brought before the court, which was relied upon without objection by any party. To the extent that the department was denied due process or states that they were denied due process, when the judge says to the department's counsel, do you have any evidence to bring before me? Do you have anything to bring before me to show that these children are at risk? And they say, I don't know. I don't know that the judge could have possibly made a contrary determination.
Is there anything about the notice of hearing on this motion which would indicate either that it would or would not be an evidentiary hearing? Or how much time was set aside for it? Anything that can be argued for whether somebody was on notice that they ought to have witnesses there?
There is nothing on the notice that says whether it's evidentiary or not.
Is there a time frame? How much time has been reserved for the hearing?
There is not. There's not a time frame reserved. However, and this may be by implication, when filing the motion, the guardian ad litem did prepare a brief in support of the motion, and that brief extends.
And it appears to raise factual issues about the kids, not just legal issues about the sufficiency of the plea, correct?
It says specifically, and this is on page 321 of the record, there is little question that we do not have a mandatory speedy trial rule in dependency court. And the very next page, the GAL is not attempting to craft a speedy trial rule. And instead, what it states is the specific argument, in order to support an adjudication of dependency, the parent's harmful behavior must be a present threat. I omit the cites, but it states, there is no present threat to the children were they to be immediately returned to the mother's care. The children are and will continue to be harmed by remaining out of the home and unable to form the critical mother-child bond that is so necessary for the formation of a strong family unit. That's on record, the record at page 323. I think that places the department squarely on notice of the grounds of the motion. They were noticed for 25 days prior to the hearing. They did not ask to continue that because they weren't prepared. They were asked to present evidence. They declined to take that opportunity for whatever reason. And they're here now arguing that when the court made that finding that it's somehow an error. I don't see it on this record. Thank you, sir.
You had some argument? Okay. Eight minutes and 40 seconds.
May it please the court. My name is Tom Young, and I'm here today on behalf of the Guardian Ad Litem program. This case is significant because case law does not presently tell us how the trial court is to vindicate the child's right to enforce the time limits.
How about moving to have the adjudicatory hearing rather than moving to dismiss the complaint?
Well,
or the petition, wouldn't that accomplish that purpose?
That certainly is one alternative. Often, it's not.
Well, in this case, trial dates were set. It's just that the trial didn't take place on those trial dates, and the trial court just bumped the adjudicatory hearing over. Isn't that correct?
That's correct, and we don't know if that the court ever made an inquiry.
We don't know why the trial court did that, do we?
We don't know why the trial court did that, and we don't know what the trial court did. We do not know whether the trial court made an inquiry into the best interest of these children. If you look at the statute, and the 2006 legislature moved some things around and added some things, but the statute today is 390136, and in subsection 1, it says that the time limitations are the right of the child, so you have a clearly delineated right.
Is this question then about remedy? That is, if an adjudicatory has been set and continued and we don't know why, that the remedy is to file a petition to dismiss, file a motion to dismiss the petition because the child's either been rehabilitated, not in danger, or the mother's been rehabilitated, not in danger, or that an adjudicatory hearing should be held as quickly as possible, depending on the court's choice.
I think that is, either of those are acceptable alternatives. The statute also allows the court to dismiss on its own. It allows, if a party requests a continuance, this is in 390136(2)(b)(1), requests a continuance based on the unavailability of evidence, and the party is not ready for trial within 30 days. The statute unequivocally allows the trial court to dismiss or any party to file a motion for an order to show cause.
Did you call witnesses to testify at the motion to dismiss hearing?
No, Your Honor. The trial court, between the guardian ad litem attorney's argument and the presentation by the department's attorney, inquired of the guardian ad litem volunteer who staffed the case. She was not placed under oath. No one requested that she be placed under oath, and the department did not ask her questions. They certainly could have.
Was the motion to dismiss contemplated to be an evidentiary matter or not?
I believe so, Your Honor, because it was predicated on the mandatory time limitation and the children's best interest.
You agree that the time delay in and of itself would not have been a sufficient basis to dismiss the petition in this case?
That's correct. I believe that the children's best interest always are going to dictate whether a petition should be dismissed. And best interests are always a highly factual matter. In this particular case, the guardian ad litem program had been filing reports back in September 05. The report, which is in the record, asked that the adjudicatory hearing be set, and at that time I believe it was, or be heard. I believe at that time it was scheduled October, November. At that time, the guardian ad litem program was advocating that the mother have unsupervised visits with these children, but the unsupervised visits didn't occur for another 6 months until February of 06, again when the guardian ad litem program had to file an affirmative motion and the magistrate ordered it. So the guardian ad litem program was doing things in the trial court, perhaps not with an affirmative motion, but in the guardian ad litem reports was advocating that the adjudicatory hearing be held, that visitation be occurring, the visitation be unsupervised. This was a fairly thin petition. The children were obviously injured significantly with second-degree burns, but it wasn't clear whether it was intentional or whether it was an accident. The mother always maintained it was an accident. There was something to do with the criminal investigation or Child Protective Services investigation that suggested maybe there was more to the story than she was letting on, but there was never any clear evidence that this mother was willful in what she had done or what had happened to the children. And over time, she had done this case plan, which had, by the way, never been approved by the trial court, so this was all voluntary compliance on her part. She was spending 5 hours a day with the children in supervised visitation. So there was overwhelming evidence that these children needed to be placed back in the home with the mother. These were 14-month-old babies when they were removed from the home, and they were kept out of the home an additional 11 months, and they needed to be with their mother so that bonding could occur. And the guardian ad litem program had the guardian ad litem volunteer in the courtroom and available to present all the best interest evidence that was necessary to support its motion. So I believe that the trial court got it right when it found that best interest is the touchstone in enforcing the child's right to enforce the time limitations. And I would submit to the court that it requires, when granting a continuance, the trial court should be inquiring as to the children's best interest. In fact, the statute says continuances shouldn't be granted unless there are, 1, extraordinary circumstances that, 2, relate to a party's constitutional rights, or 3, the children's best interest. So,
were there review hearings held in this case? The statute requires them to be held every 6 months, so there should have been 1 or perhaps 2. Were there review hearings held in this case? Does the record show that there were review hearings?
Your Honor, there were hearings before a magistrate, and I can't recall off the top of my head how
Is there
many.
documentation in the file as to what the magistrate determined at the review hearing?
I believe there are reports and recommendations, Your Honor, yes. So, to sum up, Your Honor, I believe that the statute contemplates that the court will not grant continuances unless it is making a specific inquiry into the children's best interest, and it is finding that there are extraordinary circumstances that warrant the continuances. And in this case, there was no showing of the circumstances needed. The first continuance that was supported by a motion had to do with the psychological evaluation. Psychological evaluation really had nothing to do with how the children were injured in the first place. So it's debatable whether that would have even been an appropriate motion for pushing off the adjudicatory hearing. So we have a record that doesn't support the extraordinary number of continuances that were entered in this particular case. And given the tender age of these children, their best interest was to, as the guardian ad litem demonstrated, to be back home with their mother where they could continue to bond and flourish.
In this case, the dependency petition has been dismissed. That means they would be returned with no supervision by the department. Would that be accurate?
That's correct, Your Honor.
So in order for the department to regain entry into the case, there would have to be a subsequent act to allow a petition to be filed, perhaps shelter the children, and then the adjudicatory hearing is set. Is that accurate?
That's correct, Your Honor. The guardian asked alternatively for dismissal or reunification, which would have allowed the case to proceed, and the department took the scorched earth position at argument in the trial court that it was only about dismissal, and that's covered in my brief.
Okay, thank you. Your time is up.
Thank you.
Let me ask you, we discussed earlier the requirement, the statutory requirements that these cases be expedited. You agreed that that was a statutory requirement. The legislature has said that. And the time standards aside, my question to you is, what is the remedy when it is clear from the record that the case has not been expedited, that adjudicatory hearings have been scheduled, some at the request of the guardian ad litem? Those hearings have not taken place, and we don't know why. Over a year has gone by, and there's really no explanation for many of the continuances that occurred in this particular case. The guardian ad litem files a motion to dismiss. inquiry is made at the hearing into the best interest of the children. The guardian ad litem states that the guardian didn't believe that there was a present danger to the children. The trial court asked the department, do you have any witnesses ready to go under oath to tell us about the current condition and whether it would be currently dangerous to return the children to the mother? And the department says, I don't know. And given all that, tell me, what is the appropriate remedy in this particular case, and is dismissal ever an appropriate remedy when it's clear that the case was not expedited?
I think Judge Thompson had the answer for that when he suggested that in order to show cause issue or holding the department or in contempt of court.
So your argument is dismissal is never an option when it's clear that the statutory mandate that the case be expedited has clearly been violated. The only remedy is to hold the department in contempt or to require an adjudicatory hearing at some subsequent time?
Yes, and that's because the department was being denied due process here, and or it leads to the position where a parent's attorney or a guardian attorney or the department could go on and then through a ruling
Do you have any authority, any precedent, any cases, any statute that says that dismissal is an inappropriate remedy under those circumstances?
No, I do not. And just one last thing here. Mr. Strauss represents the father. The father's part of the petition was dismissed, so to speak. He was determined to be non-offending, and I raise that because...
Let me ask you one final question. The opposing counsel for the guardian ad litem just advised us that you basically took, quote-unquote, a scorched earth policy at the hearing, and that the guardian basically took two positions. Either one, you reunite these children with the mother so that the mother can have unsupervised visits with the children. The department will still be able to supervise, the case will still be going, or the alternative would be dismissal. His argument was, and he told us emphatically, that you took the position, and it's all or nothing, Judge. We're not interested in the middle alternative.
And I think a clear reading of that short transcript, 22 pages, shows that the judge wasn't interested in continuing the case.
What was the department's position? He clearly told us just a minute ago that there were two options that the guardian ad litem requested. Number one, reunification, the case would continue, or number two, dismissal. And he says that the department clearly took the position, we want all or nothing, we're not interested in the middle position.
I don't recall that. I can't give you an answer on that, but it is my position that the judge was saying dismissal as opposed to reunification, and so that's why he argued the way he did.
Well, in fact, what the department's lawyer said at the hearing, and I think this is after the petitioner's position was made clear and before the court did anything on the merits, was, I'd like to point out that the motion is entitled motion to dismiss, and that is what they're requesting at the very top. This is not a motion for reunification. Seems to me the motion specifically said one or the other, and for the department to take the position that since the title of it is motion to dismiss, that's all we can talk about today was probably ill-advised.
I would argue that that was the guardian's argument, though, at that hearing. And one final thing, as I started to say, the father was not offending. He was dismissed from the petition, so to speak, and so I don't know what that means as far as the father's argument here today. The mother is not here, and I think that's significant for the court to think about.
When you said the mother's not here, do you mean being represented here?
Correct. She did not appeal.
Okay.
I understand that it was driven by the guardian ad litem's office, and I don't know what the father's attorney being here and the mother's attorney not being here means. I'm just raising it for this court. Thank you.
Okay, thank you very much. We'll argue it on both sides. Is there Mr.